Hello and good evening, both Ms. Nabila, Ms. Chan. We are going to cover chapter number 17 and chapter number 18. You can expect at least 8 questions from these two chapters. In civil litigation and evidence, we have three particular chapters that are focused on the evidence part: chapter 17, chapter 18, and chapter 19. And if you combine them, you can expect at least 12 questions in the exam, and they all are easy in nature. So let's start with question number one. In evidence of fact chapter, we are primarily going to talk about the different methods we have when it comes to evidencing any fact. What do I mean by that? If I am claiming that Nabila has breached some contract, or if I am saying that Miss Chan has caused me personal injury, that's just a fact. Putting any fact in allegation is not evidence itself. I need to bring on record some evidence to prove that whether this thing actually happened or not. Question number one. Lorraine has brought county court proceedings against Quality Retail Limited QRL, claiming damages for personal injuries sustained when she slipped on some squashed fruit on the floor of QRL supermarket in Liverpool. In its defense, QRL has alleged that it had taken all reasonable steps to ensure that slipping hazards were reported and a member of staff on permanent duty to clear them up. A notice to admit fact was served 4 months ago on the defendant, asking it to admit that it had inadequate system for reporting and clearing up slipping hazards. QRL acknowledged receipt of notice, but no substantive response has been made. Which one of the following is the correct advice you should give to QRL on the consequences of failing to respond further to the notice? Now, notice to admit fact is a type of method through which you can evidence any fact. For example, if there was a contract between you and me, right? And there is a dispute in relation to the contract, I filed a contractual claim. What I can do is I can serve you with a notice to admit fact, asking you to at least admit that there was a contract between us. So in the court, I'm just going to focus on the breach, not the existence of contract. So a party is supposed to serve the notice to admit fact on the other party at least 21 days before the date of trial. The idea is you don't want to prove every single thing in the court if you can just get it admitted before the actual trial. Now, in this situation, the claimant has sent the notice to admit fact to the defendant 4 months ago. The defendant did acknowledge the notice but has not filed any response. What are the consequences? What should I advise the defendant about the consequences of failing to respond further to the notice? Option A, that it will be deemed to admit that it had inadequate system for reporting and clearing up slipping hazards. B, that there are unlikely to be any adverse consequences because the notice seeks to obtain an admission of a central part of QRL's case. C, that the burden of proving it had an adequate system of reporting and clearing up slipping hazards will have shifted to QRL because it failed to respond to the notice. And D, that QRL are likely to be ordered to pay all Lorraine's cost of the proceedings regardless of the overall result at trial. Where a defendant has failed to file the response, what is the possible consequence? Ms. Nabila saying A, that it will be deemed to admit that it had inadequate system for reporting and clearing up slipping hazards. I'll wait for Ms. Chan, then we can decide. Ms. Chan is saying A. Congratulations to both of you because A is the wrong answer. Why is this wrong? Because if I, as a claimant, am serving you with a notice to admit fact, right? Either you are going to admit the notice or you are not going to file any response. If you decide not to file any response, that does not mean that it will be deemed to be admitted. That means now I will have to go to the court and prove that there was a contact between us. Then what's the possible consequence? The court can impose a cause consequence on you because you did not decide to accept the fact, and ultimately I had to put some resources into it, eventually go to the trial and prove it. So when I serve a notice to admit fact on any party, if you admit that fact is proven, If you fail to do so, I will have to prove that fact in the court. If I prove it, the court can impose a cause consequence on you for failing to admit it. Now, based on this explanation, what do you think is the correct answer? Because A is not the correct answer. Sir, can you explain about this question again? Yes, Ms. Chan, there is one claimant, there is one defendant. It's a PI claim because the claimant slipped on the floor of the defendant's supermarket in Liverpool, right? In the defense is saying that I had taken all the reasonable steps and I also had a member of staff on a permanent duty to clear them up. Now, you as a claimant served a notice on the other party. You are asking them to admit the fact that it had an inadequate system for reporting and clearing up sleeping hazards. Now, the defendant has acknowledged the notice. They are saying that yes, we did receive the notice, but they have not filed any response. They have not admitted or filed any response to it. What is the consequence if any party fails to respond to the notice to admit fact? Let's talk about option number D. Option D says that QRL are likely to be ordered to pay all Lorenz cost of the proceedings, regardless of the overall result at trial. Do you think this statement is correct? That ultimately the court will ask the defendant to pay all the claimant's costs, irrespective of the outcome of the trial? This is clearly the wrong statement for a simple reason because if ultimately the defendant wins the case, she will not be asked to pay the claimant's cost. Now let's talk about option number C. C says that the burden of proving it had an adequate system of reporting and clearing up slipping hazards will have shifted to QRL because it failed to respond to the notice. What do you think? If I serve a notice to admit fact on you, you did not file a response, does that mean that now you will be required to prove it, or will still I be required to prove that you were negligent? Because the burden is always on the party who is putting any allegation, right? If I am saying that you have breached a contract, I serve a notice to admit fact, you fail to file a response, does that mean that now the burden is shifted? Now you will have to prove there was no breach? Or still the burden will be on the party who bought the case? Do you think statement C is correct? Statement C is also wrong. Now we are left with option number B. That says that there are unlikely to be any adverse consequences because the notice seeks to obtain an admission of a central part of QRL's case. Now, this is interesting. Why? Because I said whenever you file a notice to admit fact, the other party either is going to accept it or they are going to refuse it. If they refuse and ultimately you prove that fact in the trial, the court has the discretion to impose cause consequence on the other party. In this situation, because they have failed to do so, if tomorrow the court decides to impose cause consequence, will they do it or not? In the given facts, it is unlikely. Why? Because when you are filing the notice to admit fact, essentially you are asking them to just admit your case. Imagine. You are not saying that, for example, the notice could have been, please accept that I was in the supermarket, so I don't have to prove my presence. The claimant is saying you just need to admit that you had inadequate system for reporting and cleaning up sleeping hazards. So essentially, if the other party accepts this, that's an admission of the entire claim because that is the entire claim of the claimant against the defendant. In this situation, it was reasonable for the defendant to not admit it because if he admits, he's essentially admitting the entire case. When the entire purpose behind notice to admit fact is not to admit the entire case, but to admit any fact, so that fact is no longer needed to be proven in the trial. So we can focus on the important parts. For example, if you and I had a contract, you breached it. If I say, please admit that you breached the contract, that is not the purpose of notice to admit fact. The purpose is please admit that there was a contract. So now in the trial, I'm just going to focus on the breach part. Does that make sense, Ms. Nabila, Ms. Chan? All right. Question number 2. Which one of the following propositions concerning notice to admit fact is wrong? So we are trying to identify that whenever some party uses the method of notice to admit fact, which of the proposition is wrong? Option A. An admission made by a party in compliance with the notice to admit is made for the purpose of that claim only. So any admission you make that is confined for the purpose of the claim in which the admission is made. You cannot use it in any other subsequent proceeding or for any subsequent purpose. B. An admission made by a party in compliance with the notice to admit may be withdrawn with the permission of the court. So if a party makes an admission, we are saying that admission can still be withdrawn if the court grants the permission. C. An admission made by a party in compliance with the notice to admit fact may not be used in favor of any person other than the person by whom the notice was served. So, for example, if I am the only claimant, Nabila and Ms. Chen, you are two defendants. Nabila asked me to admit a fact. Only Nabila can use that admission if I make it. Ms. Chen cannot do it because the law is simple. The party who served the notice to admit fact, if that fact is admitted, that can only be used by the party who served the notice. And D, a party who fails to reply to a notice to admit fact will be deemed to admit the facts stated in the notice. Which statement do you think is wrong? Based on the explanation I gave for question number one, this should be easy for you. Ms. Nabila is saying option number D. I think it's C, but I'm not sure. The correct answer is option number D, because all the other statements, they are clearly correct. Also, Ms. Chan, if you ever encounter any question where you're not 100% confident, just know that when the question are asking for something wrong, three statements are correct. We are only trying to identify one statement that is wrong. Now, why this should be easy for you? Because I literally just explained in question number one that just because any party fails to file in response to notice to admit fact does not mean that they have accepted. This is why this statement is wrong, that a party who fails to reply to a notice to admit fact will be deemed to admit the facts stated in the notice. That is not the correct position. If you fail to file a response, I will then go to the court and prove it. All the other statements, they are literally the description of notice to admit fact. So all those statements are correct. That you can only use it for the claim or for the proceedings in which you obtain the admission. B is also correct. Once you make an admission, you can still apply to the court and the court has a power to allow you to withdraw the admission. C is also correct. Only the party who has served the notice to admit fact, if that fact is admitted, only the party who served the notice can use it. Question number 3. Gerald has brought a claim for breach of contract against Molten Trading Limited. It is believed Ether, who has no direct connection with either party, has a file of papers that may be relevant to the issues in the claim. It is also believed that Ether has no knowledge of facts that might be relevant to the issues in the claim. So we have a claimant, we have a defendant, there is a third party named Ether who has no direct connection with either party. He only possesses a file of papers, and those papers are relevant to the issues in the claim. He has no direct knowledge of the facts, so oral evidence is not something we are looking for. He only has some file of papers that are relevant. Which one of the following statements about this potential evidence is correct? How can we use Heather as a witness in this case? Option A witness summons may be issued, limited to requiring Heather to attend court to produce the file of papers. B. A witness summons can only be used to require Heather to attend court to give oral evidence. C. A witness summons will require Heather to attend court to both to give oral evidence and to produce documents. And D. A witness summons is limited to requiring a witness to attend court for the trial. Now we have a witness and you want to issue summons against him. What should be the purpose? A, B, C, or D? Ms. Chan is saying option number C. That means Ms. Chan did not read this statement clearly. If I read it for you, Ms. Chan, it is also believed that Heather has no knowledge of facts that might be relevant to the issues in the claim. Because he has no knowledge, why would you call him for oral evidence, right? He only possesses some file of papers. So oral evidence is something we are not looking for. The correct answer, after Ms. Nabila decided to edit, is option number A. That you are going to issue the summons for a simple reason that the witness, who has no direct connection with either party, has a file of papers. So we are just going to issue the summons for the witness to produce the file of papers. His oral evidence is not required because he does not have any knowledge of the facts that might be relevant to the case. Ms. Chan, is that clear? Question number 4. In a claim for breach of contract allocated to the multi-track, Conan serves the other party, Diana, with a list of documents pursuant to a direction for a standard disclosure of documents. Which one of the following statement about the consequences of this is correct? Option A. Diana is deemed to admit the authenticity of the documents in Colin's list of documents unless she serves Colin with a notice to prove the authenticity of the documents. Option B. Diana is only deemed to admit the authenticity of the documents in Colin's list of documents if Colin also serves her with a notice to admit the authenticity of the documents. C. Diana is deemed to admit the authenticity of the documents in Colin's list of documents unless he makes an application to the court seeking declaration of non-authenticity. And D. Diana is only deemed to admit the authenticity of the documents in Colin's list of documents if Colin follows up service of the list of documents by making an interim application to the court seeking a declaration of authenticity. The concept that you need to remember is if I serve a list of documents on you, there is a presumption that you have admitted those documents unless you serve a notice on me requiring me to prove that document. Based on this concept, identify the correct answer that in a breach of contract, Colin serves Diana with a list of documents. What are the consequences? So, Ms. Chan, when we are talking about notice to admit document, we also discussed initially about notice to admit fact, right? Both of them have different ways of seeking an admission. In a notice to admit fact, the party who wishes to get the admission, I have to serve the notice on you, right? In notice to admit document, whenever I serve the list of documents on you, let's say I'm claimant, you are a defendant, I serve the list of documents on you. Under law, it is a presumption that you have admitted those documents unless you serve a notice on me requiring me to prove those documents. The correct answer is option number A. You must remember between notice to admit fact and notice to admit document, there is a 100% guaranteed MCQ in the exam. Even in the last session in December, there was one question. It was the last question in paper number one. Paper one, they were talking about whether you have to serve the notice to admit fact. How much time do you have to serve it? So remember, you have to serve the notice to admit fact at least 21 days before the date of trial. In this situation, why option A is correct? Ms. Chan is saying admit fact and document is the same thing. No, they are completely different. Admit fact is when, let's say, I take a piece of paper, I write it down that Ms. Chan, please accept that there was a contract between you and me. So that's a factual admission. Document is when I serve a document on you. In notice to admit fact, I am asking you to admit it. I am giving a notice to you. In notice to admit document, I have just given a document to you. You are under an obligation, if you wish to challenge it, to serve a notice to prove the authenticity of the documents on me. So there are two different ways. In this question, why A is the correct answer? Because it says Diana is deemed to admit the authenticity of the documents in Colin's list of documents unless he serves Colin with a notice to prove the authenticity of the documents. This is the correct statement. When the claimant has served Diana with the documents, it is going to be deemed as if she has admitted, unless she serves a notice on the claimant. Let's talk about B, C, and D. B says Diana is only deemed to admit the authenticity of the documents in Colin's list of documents. If Colin also serves her with a notice to admit, this is not a requirement. The claimant is not supposed to serve a subsequent notice to admit the authenticity of the document. Nabila is saying, what did you say about admit facts, sir? See, if there is any fact in this chapter, we are talking about that there are multiple ways, right, to prove it. We are focusing on two methods now. Notice to admit fact is a separate method. Notice to admit document is a separate method. In notice to admit fact, I pick a piece of paper. I write a fact that I want you to admit. So there's not a document. I'm writing a fact that please accept, Nabila, that there was a contract between you and me that I'm going to deliver 15 sessions to you. Either you're going to admit it or not. So I'm giving you this notice. In notice to admit document, if let's say there was a contract between us, when I disclose the copy of the contract on you, under law, there is a presumption that you have admitted that contract. If you wish to challenge it, now you are under an obligation to serve a notice on me, asking me to prove the authenticity of the document. So, in notice to admit fact, I am sending you the notice. In notice to admit document, the other party is going to ask me to prove that document. Is that clear, Mr. and Ms. Nabila? I'll just go through the remaining three statements as well. B says that the claimant is supposed to serve a subsequent notice to admit the authenticity of the document. That is not a requirement. I serve the documents, you are under an obligation to ask me to prove them. C says that she will be deemed to admit the authenticity of the documents unless she makes an application to the court. If you wish to challenge any document, you don't have to necessarily file an application in the court. You will just simply serve a notice on me asking me to prove that document. And D says, Diana is only deemed to admit the authenticity of the documents in Colin's list of documents if Colin follows up service of the list of documents by making an interim application to the court seeking a declaration of authenticity. That is not a requirement. I serve the documents. Under law, there is a presumption that you have admitted it. Unless you wish to challenge it, then you can ask me to prove them. Question number 5. Which of the following statement about depositions is or are wrong? Remember the method of deposition? In this method, you are asking the court to collect the evidence of a witness who is, God forbid, suffering because of some terminal illness, or he is going to move abroad, right? He will not be here on the day of trial. So you want the court to examine someone to collect the evidence of a witness before the date of trial. So in relation to depositions, which of the statement is wrong? Statement 1 says, a party may apply for an order for a witness to be examined before the hearing takes place. 2. A deposition has to be taken before a district judge. 3. If the witness fails to attend the examination, the party seeking the deposition may issue a witness summons to secure the witness attends a relisted appointment for the examination. And 4. An order for a deposition to be taken may also order the party who obtained the order to serve a witness statement in relation to the evidence to be given by the witness. Which of these statements are wrong in relation to deposition? My assessment confirms me that you guys are not well versed with chapter number 17. And that's not a good indication because this is extremely easy. Do you guys know what deposition is, by the way? Miss Nabila is saying, I think D. Okay. Miss Chan, pick an answer for me. Identify the wrong statements. Okay, let's do it together. The first statement says, a party may apply for an order for a witness to be examined before the hearing takes place. Is that correct or incorrect? Now, because that is the correct statement, I will remove option A from my exam because I have to identify the wrong statement, right? So now we're left with B, C, and D. Second statement says a deposition has to be taken before a district judge. Is that correct or incorrect? Now, because that's a wrong statement, why? Because deposition can be taken by a district judge or any other person whom a district judge is going to assign or ask someone to become the examiner, right? So it is not a requirement that a deposition has to be taken before a district judge. Now, this is the wrong statement. I'll go to the options. I will see that option number C does not have statement number two, right? So now we are left with B and D. So second statement is wrong. I will just focus on third and fourth. So these are the two things we have to focus on now. 3 says, if the witness fails to attend the examination, the party seeking the deposition may issue a witness summons to secure the witness attends a relisted appointment for the examination. And 4 says, an order for a deposition to be taken may also order the party who obtained the order to serve a witness statement in relation to the evidence to be given by the witness. Now, both of you have said that the fourth statement is wrong when in fact that statement is correct. Why? Because remember the general rule about evidence of fact, it is entirely the discretion of the court how they want to go about the evidence. So if the court has ordered for deposition to be taken by the party who obtained the order to serve a witness statement, that party can be asked to serve a witness statement as well. So if the statement you read it clearly, an order for a deposition to be taken may also order the party who obtained the order to serve a witness statement in relation to the evidence to be given by the witness. So in deposition, for example, if I am the witness, you apply to the court for asking the court to collect Farhan's evidence before the date of trial. The court has the discretionary power to also direct you to first secure Farhan's witness statement and then you are going to carry out the deposition. Deposition includes examination, cross-examination, re-examination. Now, obtaining witness statement is not mandatory, but it is the discretion of the court. If they wish, they can ask you to first obtain my witness statement and then collect deposition. Now, why is statement number 3 wrong? It says, if the witness fails to attend the examination, the party seeking the deposition may issue a witness summons. That is not the correct approach. If a party fails to attend the examination, you go to the court and inform the court. Then it is the responsibility of the court to decide what they have to do next. Either they are going to compel them or they are going to look into the reasons. The default rule is not that you will go and apply for witness summons. Is that clear? Question number 6. Your client's Bolton Compressors PLC are asking you whether it will be possible to obtain copies of the other side's witness statement in advance of the trial of its claim for breach of contract. So your client is asking that is there any possibility that you get to look at the other party's witness statements before the actual date of trial? Which one of the following is correct? Option A, witness statements are never disclosed because they are protected by legal professional privilege. B, witness statement must always be served 2 months after the claim is allocated to a case management track. C, the court will make an order for the exchange of witness statements provided the claim is allocated to either the fast track or multi track. Also include intermediate track here as well because initially we did not have intermediate track in our courts, but after October 2023, now we have fast track, intermediate track, and multi track. And D says exchange of witness statement only occurs if the claim is proceeding in the Admiralty and Commercial Court. Which option do you think is correct if you want to have a look at the other side's witness statements before the date of trial?